Good evening, everybody. Today is October 24th, 2024. This is Tad with YouHaveTheRight.com, and we are joined tonight with Ron Gibson. And Ron Gibson is a man that is very well versed in law. He is, in my opinion, America's foremost expert on land patents. And he learned about law and land patents by being a minor and going head-to-head with the Bureau of Land Management. And Ron has many other accomplishments. He's written, I think, 2 books, one on land patents, and I think one on law. Is that correct, Ron?
Well, one of them is what you need to know about land patents, and the other one is you're not a slave, and that has to do with property tax. I proved it.
All right.
Obligated to pay property tax.
So, you're here with us tonight, Ron, and I thank you very much. You are a font of information and wisdom, and I recently learned about what is known as the Chevron doctrine or the Chevron decision, and that came up in a recent court case. And in our discussions, you had said that when the Supreme Court overturned this decision, that it cut the federal agencies off at the knees. So maybe you can start and tell us about this case and why it's so significant.
Well, some years back, and I don't remember exactly the date of the court case of Chevron, was an environmental lawsuit against Chevron for an oil spill. And in and through that case, get to the bottom line of it, the government agencies, blowing it way out of proportion like they do everything else, made it look like the courts needed to defend them in actions that they take under statutes and codes, or more to the point, decisions made behind the agencies, all agencies' desk, and then call them law for the sake of implementing the action of the court. And that went on for a number of years. And then finally there's a case that came down, which is West Virginia versus the EPA. And the EPA had been doing that for years and ruining people's lives and taking their land and whatever. And the case was very well argued. And the Supreme Court said you can't do that anymore because what they're implementing is not law. Therefore, it has more enforcement authority. And so that really crippled the ABC agencies from implementing any more fines and prison sentences and all kinds of court action relative to any kind of subject matter that they wanted to implement a hardship on an individual or a company. But anyway, the Supreme Court really put a kibosh on it, which they did rightfully so. They should have never agreed in the Chevron case way back when either, but a lot of people have suffered because of it. But anyway, I guess all things come in due season. So that's the Reader's Digest version of that.
So what does this mean for us? You know, you're dealing with BLM. I know there's a lot of ranchers and things like that are dealing with BLM, and then you have the Environmental Protection Agency. And then there's the ATF. They make up these rules as if they're law, and they prosecute people. But at this point, if we are coming up against a federal agency, what does this mean?
Well, it means that they can't prosecute. They can't infringe upon your rights or your protective means to protect yourself by due process. They just come along and write you a citation, fine you, throw you in jail, and the courts have upheld that. because of that original Chevron decision. So it means that none of that can happen in the future without them getting their butt in hot water, because it's not law. There's a purpose for law, isn't there? And what people don't understand about law is law is intended to bring peace, not conflict.
Right.
Statutes and codes bring conflict and confusion. But they've taken way undue advantage of the Supreme Court's ruling, in reference to the Chevron case, that they would back up the government agencies even though it wasn't law. And that's what they did. And that's what the West Virginia versus EPA case was about. So, unfortunately, they got it stopped.
So does this mean that these agencies are just suddenly going to stop what they're doing, or are they just going to keep going?
Well, they have to stop, because now they become personally accountable. They fall under what's called a constitutional tort. A tort is a damage claim. When you have been damaged by an agency or a person of that agency, and you do stuff according to what is decided behind their desk, now they've got a problem. Because in many cases, it constitutes a compensatory taking, which is a taking without lawful cause to do it. And that's what they're trying to do in the Dakotas there for people that ranches, and they're trying to take it by eminent domain. Battens are not subject to eminent domain. But it doesn't matter whether it's there or whether you're a truck driver, you got a truck shop, or, whatever. They can't implement any kind of enforcement action without having law, not the force of law. And that's what they've been using. These behind-the-desk policies and procedures have been used as law. No authority for that at all, anywhere, anytime. But that's what they did for that period of time.
Okay, so speaking of truck driver, I know there's a lot of truck drivers out there, and I'm licensed as a truck driver myself. So let's say you go into the scales, and you got to deal with these butt heads that are in there. Does this decision change that at all?
Well, it would change it if, in fact, they're acting out of law. The thing you need to remember, statutes and codes are not law. Those are corporate rules and regulations.
Well, the belief is that you have a license, you signed up for it, you agreed to it.
Well, there is some truth to that.
Okay.
There is some truth to that. That's why you want to be careful what you sign up for.
Okay.
But even within that realm, you still have protective covenants if they're abusing that position that they're in and not predicated upon. See, statutes and codes have been accepted as law. That's what the West Virginia case really touches into, although it specifically wasn't talking about statutes and codes. They were talking about policies and procedures.
Okay.
But as long as you have a commercial driver's license, then you are under their jurisdiction.
And that goes for any license, is that right?
Yes, it is. That's just why I don't have a driver's license. I haven't had one for 35 years.
And then you've been pulled over and they try to harass you and you win every time, is that right?
Yeah, well, there's a couple of times that I didn't, but I beat it in the long run, but the initial round I didn't, because they're ignorant. They don't know what the law is. When I went to trial on it, and in essence approved, and all you got to do is to go to Title 49 in the United States Code, and it spells it out. What is a driver and what isn't a driver? And for you and I to go to the grocery store, take kids to school, or go for a joyride is not subject to a license. Only when you're in commerce. Somebody's got to be paying you to drive that vehicle for a specific purpose.
All right.
Your vehicle, when it's not in commerce, is private property, not public property, not publicly controlled property. And these officers are taught that any time you get behind a wheel, you're a driver, therefore subject to their jurisdiction.
Okay.
That is absolutely not true.
So back to Chevron. Is there anything else you want to say about that, or any lessons that you want to glean before we go to questions?
Well, I can't think anything off the top of my head.
Okay.
But I try to encourage people to learn a little bit about the law. You don't have to know all the law. It's not necessary at all. But the federal courts have ruled over and over and over. You don't know the rights, you don't have any rights. You know, I try to encourage people to read the Constitution. My golly, what an incredible document that is.
Yeah.
And 99 people out of 14 don't even know what the hell it says. Anyway.
Would you say 99 cops out of 14?
Anybody, 99 out of 14. The point of it is we'll watch the 6 o'clock news and think that that's gospel, when in fact the Constitution has tremendous amount of protective covenants about it. But people won't spend enough time to learn a little bit about it so they can defend themselves. They can't go defend it.
So
I wish I could.
Are you up for some questions right now?
Yeah.
Okay. We'll go to area code 816, Kansas City. Go ahead.
Okay. Hi, Ron. I've spoken to you on the phone before concerning this property tax sale of my folks' home of 73 years. And in my...
So if we can keep this on to the Chevron decision. This is the Chevron decision question?
Yeah.
Okay.
Yeah. Yeah. And okay. So from what the discussion you two have been having, this is the property tax so-called agency of the city or county so-called government makes a decision that somebody hasn't paid a tax, therefore the agency can sell their property. Now, there's no property tax laws that I can determine on any state, in any state, in any county, in any city. There's nothing there. So how does the Chevron case, and I'm interested too from the aspect of the land patent, which you've touched a little bit on. So where do you see the Chevron overthrow concerning court backup of these agency selling of people's property when there's not even a law?
Well, the simple answer to that is, you're right, there is no law, but they just do it because the American people are afraid of them. It's kind of like the Internal Revenue Service. Internal Revenue Service, they'll tell you owe tax, and if you go study just a little bit, take 5 minutes, and you'll find out you're not a taxpayer.
That's
you're
right.
Obligated to pay a tax. And as an individual, you're not a taxpayer. So therefore, why don't you go guys play on the fast lane and the freeway?
Yeah. So just real quickly to throw in there for people who are listening, go download a copy of the IRS form W-4V and sign it. Say I don't want to pay anymore. It's a simple form, and read the front and the back real careful. It's an IRS
There you
department.
go.
All right.
And
Thank
you
Wait a
talk to
minute.
100 people about that, they don't know. Because they don't know fucking studies.
Wait a minute. On the property tax thing, so I want to know with Chevron, with the overthrow of Chevron, how do you suggest that someone go into like a confirmation hearing in the court based on an agency action, that being an agency of the city that's selling people's property? How do you suggest that we use this overturn of Chevron in that? Do you have any thought on that?
Well, the easiest way to dispel a property tax sale is that you have to sue the individuals that are perpetrating the action, because there is no law of what allows them to come and take another man's property with the stroke of a pen. And it's a constitutional violation under Article 1, Section 10, Clause 1. It's called a Bill of Attainder. A Bill of Attainder is a legislative act which the states claim they have legislative authority to tax private property. Well, there's a problem with that, and that is the fact that there's a maximum law that is universal all over the world. God himself created it, yes. And that is the fact that one can only claim jurisdiction over that which one creates.
Yeah.
Where the state or the county or the city create the land.
So with that, and the court knows that there's no property tax law, and yet they're backing up this sale by this agency. That's where I think the Chevron overthrow comes in and the new ruling should be pretty strong. Am I not understanding something correctly to think that way?
Well, you're right on the money. The implication and effect is the same, exactly.
Okay, so we got to move on. 970, you're next. Your phone just unmuted. Go ahead. Be sure to unmute your phone. By the way, if you have questions for Ron, hit *6 on your phone, and then I believe 1. *6 and 1. Okay.
Here. Hi, Ron. Hi, Thad. How are you?
There we go.
Okay, so it's my understanding that the Chevron being repealed, doctrine being repealed or overturned, the courts are no longer allowed to follow the guidance of the corporations. They're now being forced to follow laws, not just these statutes and codes. Is that correct?
That is correct.
And then, so in New Mexico, I'm in the process of a tail end of a foreclosure situation, and they've denied my due process. They've denied my challenging of them doing their jurisdiction, and so the statute is such that they tried to force me to contract with them under their statutes and their settlement programs, but I said, you can't force me to contract. That's against the Constitution, and then that made him even more mad. So how would me raising this Chevron deference when it comes to a hearing, how would I go about doing that, or how would I benefit by bringing up the West Virginia versus EPA that they're no longer allowed to follow the guidance of the corporations? They actually have to follow law. So I'd have to just cite my constitutional rights and how they're violating their oath of office on the record?
Yes.
And then so bringing Chevron doctrine would help and showing that they can no longer refer to the codes and statutes if they have to actually follow constitutional law.
That is correct. No statute can supersede a constitutional protected right.
And so in raising my right, then they have to honor that right. Is that correct?
So, yes.
Otherwise, it's an infringement of a violation of their oath and is technically treason against the Constitution.
That is correct.
Okay, thank you.
All right, thank you.
That.
Let's see. The way they do this is so haphazard. 586 area code. Your phone just unmuted. Go ahead.
I believe that's me. I've got
Yay.
3 hopefully relatively short questions. Ron, are you at all concerned for your safety or well-being because of the work you're doing as a patriot?
I'm sorry, say again?
Are you at all concerned for your safety or well-being because of the steps you're taking as a patriot?
Yes. But, I don't worry about that.
It's all we got.
And, if that's the way the Lord wants to take me home, then so be it. And then I'm going to keep doing what he wants me to do.
Okay, next brief question. Previous victims of...
What was that,
I
Ron?
agree with you.
Up.
No, I said some people have warned me about that I need to be careful, and I don't go out and do stuff stupid, but I don't worry about that. If that's
Good
the
for
way
you.
God wants to take me, so be it.
Yep. The previous victims of rulings that were done illegally under the original Chevron doctrine, will they have any recourse against the government?
They do, but I doubt that the government would honor it because they would claim that it's past the statute of limitation. The government's famous for that.
Okay. My next step I'm going to take becoming a free person is getting rid of my driver's license. It's my understanding if I get pulled over and arrested, I can sue for false imprisonment, et cetera, et cetera. Is there any truth to that?
Yeah. Yes, there is.
Thank you.
All right, thank you very much. So we're going to go to 314 area code. You're next.
Yeah, thanks a lot, Ted. Ron, I was just wondering, the overturning of the Chevron doctrine, wouldn't that pretty much do away with all color of law?
No. Well, let's clarify. What are you referring to as law?
Well, what the basically, as I understand it, is corporate policy is all what they're acting under now, and they call it color of law. It's not really law. I don't think there's been anything enacted into positive law in decades, so I think it's just all the different agencies making this stuff up. And somebody mentioned earlier it's because the Congress is too lazy to make a law. I think it's actually because they can't constitutionally make these laws, so they create an agency, let the agency make the laws, and then let them fight it out in court. And when they enacted the Chevron doctrine, the court said, yeah, well, we're going to honor this, and we don't have to have positive law. We could all just push corporate policy. But now they've overturned that, so wouldn't that nullify most color of law?
Yes, it would.
Okay, which is just about every traffic ticket you get is just color of law, as we all know, because it's something from the Commerce Department, has nothing to do with law. There's no positive law regulating as you said, the travel of private people in their private automobiles.
The agencies, whether it be in traffic law enforcement, code enforcement, whatever, they do what they do because we've let them get by with doing it.
Right.
And until we put a stop with that, that's going to be a big factor.
Right.
And how do you do that? It's sue them under separate cover.
Well, I'm in a court case right now where the judge because I don't have a driver's license, or I didn't, and I don't have my vehicle registered because it's not a vehicle; it's a private automobile. But I challenged the jurisdiction of the court, and she just kept saying, "Well, I've got jurisdiction. I've got jurisdiction." So enough of that. She set the date for the court case, so I filed a writ of mandamus, and now I've got another court case that's going to precede that one. That I might be able to use this Chevron doctrine case in my defense.
Well, I'm glad that you challenged that, because it needs to be. No court has any lawful authority to establish their own jurisdiction.
Exactly.
That's the reason why.
Well, there's at least a dozen cases out there saying that. And I submitted that information, but they want to just ignore it. I'm not even sure they read it, and I don't care if they read it or not, because the fact that I've submitted it puts them on the line, and they have to deal accordingly. That's why I did this writ of mandamus, and we'll see where it goes. But I certainly appreciate your responding to this and your being on this call tonight. Thank you very much.
Thank you. So you guys, the ones that are listening, if you have any questions for Ron, hit *6 on your phone. Hit *6, and I believe it's 1. Listen to the instructions. But hit *6, and we'll go to 803 area code, South Carolina. You're next.
Hello, Ron. Hello.
Hello, Steve. Oh,
yeah, how you doing? It's been an honor to speak to you. I've been trying to get in touch with you for 4 years now, because we lost our land due to fraud upon the court. Do you still help assist into land grants?
No.
What was that, Ron?
I said yes, I do. I think the question was, do I still assist in helping people put their land grants together? And my answer is yes.
Yes, but how can we go about getting in touch with you or set some up with you?
I'm sorry, you broke up. Say again?
I said, how do we go by setting some up with you so we can get together on this?
Well, get a hold of Thad, and he can give you my contact number.
Do what now?
He said get a hold of me through the website, youhavetheright.com. You can send me an email or respond to the email that I sent you if you got one, and I'll see what I can do to connect you.
You say youhavetheright.com, that's it?
Youhavetheright.com. I have a couple of contact links there. You can send me a message.
Okay, I sure appreciate it, because it's been an honor, because we've been trying to get in touch with you for 4 years, because it's been a crazy ride in South Carolina.
All right, thank you for calling. Oh, did you have something else you wanted to say about that, Ron?
No, that's all right. Go ahead.
All right. 617 area code. Go ahead.
Thank you, Ted. And thanks for joining us, Ron. My question is, sure. My question is, would this be able to void a judgment? I know somebody earlier asked if there was recourse for violation of rights, but what about voiding judgment, particularly if someone was paying restitution and things like that? Would like a notice of void judgment, would you be able to cite this decision to do that? And if not, what would the best route go to be able to void a judgment?
Well, you would have to file what's called a motion to vacate the judgment based upon the West Virginia versus EPA case, because the implementation of that lawsuit and the judgment that was rendered was based upon the court backing up the agencies for something that's not law. Now, what the court may say, well, that's what was being done at that time, and now it's overturned. So the enforcement arm continues on. I mean, I don't know. I'm just throwing some thoughts out there to you that you need to consider.
No, that helps. I'm trying to help a friend, so that we tried going the lack of jurisdiction route, but now I'm thinking that this might be another bite at the apple. So thank you very much. Appreciate it.
But never be afraid to challenge jurisdiction. Jurisdiction can be challenged at any time, even after a case is over. So be sure and look into that.
So I have an approach to that, Ron. Ask the judge of the three jurisdictions granted by the Constitution or established by the Constitution, Articles 1, 3, and 4. Is that correct?
That's correct.
So of the jurisdictions at 1, 3, and 4, which one of those three jurisdictions is this court operating in?
Well, they could be operating either in Article 1 court or Article 4.
But
Article 3 Constitution is a constitutional court.
But what I'm saying is when you're in court, that's how you phrase the question. You back them into a corner. Now, I was at a meeting here, Ron, 6 months ago or something. Had a guy running for Attorney General. You know, he gave this heartwarming speech how he was, prosecuting these pedophiles and all that and child abuse. And that's great, and that's what you're supposed to do. My biggest concern is all the innocent people they're prosecuting and they don't give a damn. And so I asked him that question. I said, the three jurisdictions, which one is your court operating in? Ron, he got so upset. He was flabbergasted. He hated that question. So it goes to show you that. Go ahead.
It's too bad whether he gets upset or not.
Yeah, exactly. Now here's the answer that he gave me. I said, which one of those three? He said, well, no, it's the Oregon Constitution. We operate under the Oregon Constitution. So how would you respond to that?
Well, if you read the Oregon Constitution, he's not allowed to be doing that either. Because we're all protected by the U.S. Constitution, that the state constitutions have to follow suit.
Well, I guess I just smoked him out as a fraud.
Well, sure they're a fraud. Otherwise, you wouldn't be there.
All right, we're going to go to area code 517. You're next. Your phone just unmuted. Go ahead.
Yep. So I appreciate your time and stuff like that, and I've been listening for a long time, and I even read your book, Ron. And I've actually listened to the conversation back with James Lovett and stuff like that. So I've got a couple things. One is from an earlier caller talking about Congress. He's got to realize Congress is a corporation. If he doesn't realize that, I've actually got a recording of General Milley admitting to it under Congress, an oath, that it's a corporation. The other gentleman talking about the driver's license and stuff like that, he's got to remember that when he signed the driver's license and stuff, he signed a contract. But my question to Ron is, and going back to the other gentleman asking about how to get a hold of him, and I think I've actually sent an email before. I know that you're busy and everything like that because you said that on James Lovett. But my question is, how do you deal with court and the clerk to accept the land patent or allodial title? Because they're pushing back, and we know that they're de facto, and the fact that they're de facto, they're not doing anything, hence the reason why they keep saying you have no standing. So how do we push into that? How do we you can't claim standing if they're not going to allow you in a de facto court?
Well, what you do is that you sue the judge and you sue the court clerk. They have to defend the fact that they are ruling against, it's called warring against the Constitution. It's called misprision of felony. That they are ruling against a constitutional document. They don't have the rule against that. But
so how do you go about suing now?
You just file a suit in federal court.
All right, so
file it under an Article 3.
No,
Go ahead.
Go ahead.
Go ahead.
Okay, so if we
You
can...
were saying which article?
Article 3.
So I'd like to keep the
Go ahead,
questions
Mary.
tonight based on the Chevron, because that's what we have Ron here to discuss. So we're going to move on to another caller. Caller, your phone just unmuted. You're next.
Hello?
Yes, go ahead.
Hi, Tad. This is Genevieve.
Haven't heard from you in a long time.
I know. I've thought about you many times. Anyway, so I'm in a situation, Ron, where the county has already found against me for lack of property taxes. And I got the eviction notice almost an entire year ago. And and I'm still battling it out. And what I want to know is, with the Chevron deference, is applicable to a county municipal court, isn't it?
Well, yes, it is, but I'm not sure that that's your strongest argument. You could use that, but I would use a constitutional tort based upon Article 1, Section 10, Clause 1. Under the Bill of Attainder.
Article 1, Section 10 what?
Section 10, Clause 1.
Oh.
110.1.
Okay, Clause 1. Okay.
And it's called a Bill of Attainder. It's unlawful. The Constitution forbids any legislative act that falls under that category. And the taxation is one of them. An ex post facto law is another one. Impairing the obligation is another one. That land patent is a forever document.
Well, I don't have, I did not complete the land patent. I tried to, but going into the county office to go through the records and take it all the way back, I couldn't think. There was so much like 5G or something like that going on. I went in multiple times and I couldn't think. So I couldn't do that records search. So what I ended up doing was posting, or that is publishing in the newspaper that I was bringing the land patent forward, and did anybody have anything to say about it? And nobody did, and so I just merrily went on my way. Well, apparently that didn't carry any weight at all with the county.
Well, the county is breach of constitutional tort because the land patent is a constitutional document, one of the founding documents.
Well, they steamrolled over me. I've sent multiple notices and affidavits, and they're still steamrolling over me. But I think I might have them backed into a corner now. But it's still a worry because, I got the notice of eviction on the front door, and it's nerve-wracking.
So Ron, I have a suggestion. Let me know how feasible this is. Go to your county clerk, do a public records request for the public official bonds of everyone that's involved with this, the tax assessor, the tax collector, everybody. And you should be able to get them. And when you get them, put in a claim on their bonds for whatever your claim is. Like what Ron pointed out, you're injured because they went outside of their authority, and now they're engaged in racketeering, extortion, whatever.
It's called an unjust enrichment also.
Yep, unjust enrichment because you owe $3,000 in taxes, but your house is worth $300,000. They're going to sell the $300,000 and keep it.
But there's another court case that just happened in Tennessee, I think. Ron, I'll bet you know about it. Where the taxes that the gal owed were something like $800, and they sold her house for hundreds of thousands. And she took it to the Supreme Court, and the Supreme Court said that you, county, cannot keep the excess that you made on the sale. So let's say they sold it for $250,000, and she only owed $850. Then she got to keep they had to reimburse her and give her back the value of her home. Are you familiar with that, Ron?
Yes, I am.
So, all right.
But see, here's what the counties are doing now to evade that issue. They sell the tax notice to a private investigator. The private investor then pays the county exactly the amount of the tax, and then let the two of them fight it out.
Oh, so they're doing it without letting anybody know that they're doing it.
That's correct. They're selling the tax due notice to a private investigator, who then, when the tax sale is concluded, then in essence he claims that he owns it because he bought the note from the county tax department.
Do you wait a minute, investigator or investor?
Investor.
Okay.
There's a third party sitting on the side to take advantage of that person that's losing their home. So they set it up with the county that they will buy those notes, and then the people have to deal with the people there in the who are the investors.
So what do you think about my approach of finding their bonds and putting a claim on it?
Well, that's fine if you can find out where their bond is, because that's called undue enrichment. That's a fraud.
I know that the Republican Party here in Lane County, they were able to get them. They ran into problems once they got them, but they got them. So, and I believe it's just a matter of making a public records request at the county clerk.
I doubt that they would be very eager to supply that information.
Well,
it might take a while.
Yeah, but it's federal law for them if they deprive of that. Now they're subject to fraud and withholding. I forget there's a name for it, but
okay.
It's better not withhold.
Do you have any idea about how far back in time that they're going to honor the ruling in the case, Ron?
I don't know that answer yet. I've been wondering the same thing, whether it's just going to be effective as the date of the ruling from the Supreme Court against the EPA, or whether there's any retroactive aspect to it.
Oh, okay.
All right, so we got some other people that have questions. So we're
I'm sure you do. Thank you so much. I appreciate your help.
Okay, area code 920. Go ahead.
I had a simple question. The guy was talking about the 1, 3, and 4 jurisdiction.
Yes.
Of what he asked the Attorney General that was going on in election.
Right.
If he could repeat that question.
Okay, so like if you're in court or if you have an Attorney General running for office and he actually allows questions, when you're brought up on criminal charges in your court, of the three jurisdictions that are established by the Constitution, Articles 1, 3, and 4, which one of those jurisdictions is your court operating in?
Gotcha.
That will put them in a corner. So, any other questions?
Would it be possible to get a certified copy of that Chevron doctrine? And the other thing is, why wouldn't we, if we're having so much problems filing into the county or getting something recorded, would we be able to get it recorded with the Library of Congress? I've heard it once or twice within the past couple of months, and that would be it.
Ron?
Yes?
Do you know how to address that question?
I'm sorry, I didn't understand the question.
Ma'am, you want to... Okay, well, she's gone. Okay,
the one question that I had for him, can we file into the Library of Congress because of the county not willing to record anything? That was the question for Ron.
No.
Okay.
You're going to file a suit like that, you file it in the federal court based upon constitutional violations.
All right, we're going to go to area code 586. You're next.
Okay, sorry about that.
Yes.
Please come back to me. I was listening to the other stuff and I forgot my question. I did not write it down, so I will.
Okay.
I'll pass for the moment.
Okay. We got time probably for one more question. We'll go back to area code 517.
Hey, appreciate it one more time. You've referred twice to the Articles 1, 3, and 4. Can you explain more on why you would back them into the corner with that aspect? I'm truly interested.
Because we are guaranteed an Article 3 court. We don't have an Article 3 court. They're operating, I believe, in Article 1, a military court. Ron, would you agree with that?
Yes, in part.
Okay, and what's the other part?
Well, there are certain cases that are of a chancery nature that go to Article 4 courts.
So, in other words, we're getting a court that we don't belong in. And they're using those courts to defraud us of our rights, our freedoms, and our money.
And your property. And your property.
And your property. And your country.
Yep.
So, all right. We may have time for one more question. We got 5 minutes left. I think Ron has to go at 7 o'clock. So if you have any more questions, if anybody on the calls, if you have a question, hit *6 on your phone, and we'll call on you. And if not, then we're going to end the call. Okay, there we go. Okay, well...
Well, thank you all for allowing me to come.
Hold on. We have... Okay. Somebody that has a restricted line, I'll call on you. Your phone just unmuted. Go ahead.
Hi, it's me again, Genevieve.
Okay.
This, since nobody else is asking a question, I'm going to ask a question regarding land patent. Is that all right?
Actually, I do have somebody else that may have a question here, so I'm going to go ahead. Somebody new. 858 area code. Go ahead. 858. Your phone just unmuted. Go ahead, please. You may have to unmute your phone.
Oh, sorry.
There we go.
The question is regarding our house that was repossessed, and is it too late to go back and try to do something with that? It's been 5 years.
How long ago has it been? How long ago has it been?
How long?
5 years,
How
Ron.
long ago did you
5
lose
years.
your house? Yeah, you're too late. If you'd have done that quicker, within 2 years, you could go back for your home for fraudulent loan. You could go back to motion for quiet title. You could go back for fraudulent activity relative to money laundering, a whole lot of things, but you got to do it within a certain time period.
Well, we fought in the courts, a lot of it pro se, for 8 years. We won one of the cases, and the last one, we didn't even get to trial. We didn't get a trial. We didn't get. The judge just said, just gave it to the bank, and we were out in 12 hours. So the chain of title was broken. There were so many issues, but we can't do anything about it now.
Well, if you have a pending case and the judge just gave it to the bank, the judge is now liable.
Yeah. Go find his bond, put a claim on that sucker.
Exactly.
And
well, she came in and did it. They got a new judge in, and they took quite a few people's homes, did the same thing that were fighting it, our friends. So the judge just handed them over the house. So we got to the judge.
Well, there's one thing that you can do, even after the fact, if you want to really clip the judge hard, is get a hold of the website, go to the IRS site, and get a 3949A form and fill it out. The judge's name, where he's located, the court he's in, da-da-da-da-da-da, and the Internal Revenue Service will come and visit him real quick. A lot of them have gone to jail. Income tax stage. So that's a 3949A form. I got to run, guys. Thank you.
Hey, Ron, how about if we have you again, we talk about property taxes?
Yeah, no, that'd be fine.
Okay. Thank you, Ron. All right, everybody, thank you very much for joining us. Again, go visit youhavetheright.com, support us, get a membership, learn about some cool stuff. And thank you very much, and good night.